Hello, welcome to Legally Speaking. I'm your host, Sophia Haynes. Legally Speaking is a public service of You and the Law, a nonprofit whose mission is to provide information and resources to empower you in your legal affairs. Although we provide legal information, it is not in any way intended to be legal advice. So if you have an issue, make sure that you retain the services of a licensed qualified attorney. Today, we're continuing our criminal justice series. We call it Criminal Justice 101. To kind of bring some information about what the criminal justice process is and all the players and the roles of those individual players. And to help us with our discussion today, and we're talking about the defense attorney's role today, we have two foremost experts in that area, Ms. Rhonda Kreuziger and Mr. Herbert Adams. Ms. Kreuziger is the owner of the Kreuziger Law Firm in Fayetteville, Georgia. She's admitted to practice in Georgia, Wisconsin, the Supreme Court of the United States. She received her law degree from John Marshall Law School and her bachelor's degree from Northwestern State University in Louisiana. Prior to becoming an attorney, she worked as a forensic serologist with the North Louisiana Criminalistics, is that what it is? Criminalistics Laboratory in Shreveport, Louisiana, and a forensic toxicologist for the SmithKline Beecham Chemical Laboratories in Dallas, Texas. After law school, she worked as an assistant district attorney in the Griffin Circuit, where she prosecuted felony, misdemeanor, and juvenile matters. Currently, she represents individuals charged with crimes and offenses in the Superior, State, Municipal, Magistrate, and Juvenile courts throughout the state of Georgia. She's a member of the Georgia Association of Women Lawyers, Georgia Trial Lawyers Association, Fayette County Bar Association, State Bar of Georgia, State Bar of Wisconsin, and the Supreme Court of the United States. In 2009, she was selected to attend the Leadership Academy for the Georgia Association of Women Lawyers. She's also served as a CLE instructor for the Clayton County Bar Association and an instructor for the DUI case preparation and courtroom presentation at the Georgia Public Safety Academy in 2009, 10, and 11. Herbert Adams has been practicing law for over 25 years. His areas of practice are criminal defense and civil litigation. His website, if you need to find him, is youdidn'tdoit.com. We have to talk to him about that one. He's a graduate of Georgia Tech, Southern Methodist University, and Harvard University. He's a former prosecutor and traffic court judge. Welcome to both of you. Thank you so much for being here.
Thank you.
Okay, as I told the audience, we're talking about the role of the defense attorney in the whole criminal prosecution scheme. I decided to put this series together because I saw a lot of misinformation as to what happened and the roles of each party in it. Even the private citizens, like a lot of people think it just happens to me and there is nothing that I can do to participate in this process. So I want to talk a little bit about that, but I want to start off, and I'll start out with you, Herbert. What is the role of the defense attorney in a criminal prosecution?
I believe the role of the criminal defense attorney is to make sure that a defendant who's charged with a crime gets a fair trial and that the state is held to its standard of proof. A defendant is presumed innocent, and that presumption never leaves him. And the burden is on the government, the state, to prove his guilt beyond a reasonable doubt. And if the state cannot prove that, then under our system, the defendant should be set free. And so I believe it's the role of the criminal defense lawyer to make sure to hold the government, the state of Georgia in this case, to its burden of proof and to make sure that people get a fair trial and that their rights are protected, because every American has certain rights, but those rights have to be protected and enforced, and you have to be informed of those rights. And it's the criminal defense lawyer's job to make sure that anyone charged with a crime is aware of his rights and that those rights are protected.
So is that role the same whether I have a public defender that's appointed by the court or whether I have the means to retain an attorney?
That is correct. That role never changes. So whether your lawyer is a court-appointed lawyer or a public defender or in private practice like myself, the role of that lawyer never changes. It's to defend his or her client and to make sure his or her client's rights are protected.
Okay, Rhonda, let's talk a little bit about how that actually happens. We talked in our prosecution show about we have an arrest that's made, warrants are alleged, and then the next thing they come to is an arraignment process. So tell us what's happening in that process as far as the defense attorney is concerned, and how are they making sure that those rights that Herbert was just telling us about are protected?
Well, first and foremost, what Herbert stated is absolutely correct. Our primary job is to make sure that the system works. We're there to make sure that the inalienable rights that every person has, that is protected under the Constitution, remains intact throughout the whole process. So from the time the person actually has the initial encounter with the police, through the process of being possibly incarcerated, through the initial appearance and the arraignment, the whole purpose, I shouldn't say the sole purpose, but the primary purpose of the defense attorney is to ensure that none of his rights have been abrogated to that point. And if they have, you obviously want to make sure it's well documented by filing the proper motions with the court. Make sure you want to preserve his rights from that moment forward. And you also want to make sure that you are perfecting a record by making the motions so that if and when the proper time occurs, whether it's a motion hearing or a normal court proceeding, you have the opportunity to bring those issues to the attention of the court.
So what do you mean by perfecting the record?
By that I mean it's extremely important. I always tell my clients, I try to win for you twice. Obviously I want to win the first time around through the trial process, either with a dismissal or we're able to win with a motions hearing, or if we go to trial, we win. But if worst case scenario, you don't win at the trial level, you have to make sure that you have properly preserved your client's rights to an appeal. And by that I mean that if certain issues have been violated, meaning certain constitutional rights have not been properly protected, it's the defense attorney's role to make sure that those things have been memorialized through your motions, either motions to suppress, or in some cases a motion in limine. And once the court has ruled on it, if you lose at the trial level, you have the opportunity to raise those issues with the Court of Appeals.
So what are some of those things that you as a defense attorney are looking at from an evidentiary standpoint to determine whether I want to bring a motion?
Well, once you file your motions for discovery, there are United States Supreme Court cases that give the defense attorneys, well, specifically it's the defendant, the right to ask for all information that the state plans to use against them. If it's a felony case in particular, you're entitled to any and all information that the state intends to use. So once you have an opportunity to get that information, you go through it. It's a checks and balance. You look at the case law to see if there are any positions that support your arguments. You look at the evidence that the state intends to present. You try to determine whether or not they have been completely forthcoming with the information. In other words, you're looking to see if there's any gaps in the information provided. If so, you bring additional motions so that they can be forced to give you that information so you can have your client. The whole purpose of that is to make sure that when you walk into that courtroom, you're in a position of I won't say superior knowledge, but you're certainly not in a position of inferior knowledge where the information that's planned to be used against your client is concerned.
So it's not a case of gotcha or they withholding stuff that you would need to know to protect yourself or defend yourself.
No, I think it's more of a case of exercising due diligence on behalf of the defense attorney. Now, not everyone will agree with that, but the truth of the matter is the system is designed to work if the parties do their job. If everybody stays in their lane, if the prosecution presents the evidence to the defense attorney, or the defense attorney files the proper motions in order to get that information, the system is designed to work that way. It's a checks and balance. Like Mr. Herbert stated earlier, is there enough evidence to prove my client guilty? And even if there is, was it properly obtained? If it wasn't, then I need to be filing motions to draw to the court's attention that even though my client, based on the face of the facts presented, might appear to be guilty, he has constitutional rights that have been violated, and as a result, the state should not be rewarded for that behavior. So the case should either be dismissed, amended, or whatever is appropriate under the circumstances.
So you're a part of that checks and balances system to make sure that the system works.
Absolutely.
Now, how important, Herbert, is it for your client to be honest with you so that you can present the proper motions and the proper information to the court so that a just result can happen?
I think it's very important for the client to be honest and forthright with his lawyer. There's a concept known as the attorney-client privilege. And what most people don't realize is that the attorney-client privilege does not protect the attorney, it protects the client. It authorizes the client to tell his lawyer any and everything about the case. I always call it the good, the bad, and the ugly, so that lawyer is prepared and will not be blindsided by the prosecution. And that information shared by the client cannot be divulged by that lawyer without that client's permission. And so it's a way to protect the client's interests, but also fully inform the lawyer. Neither the judge, nor the prosecutor, nor anyone else can then be required or can require that lawyer to divulge that information. That's the secret that the lawyer takes to his grave. And so, armed with all of that information, the lawyer is better prepared to advise the client on his or her different options and to prepare the case for trial if a trial is necessary, or to be able to negotiate with the prosecutor and to hopefully get the case dismissed or the charges reduced or whatever. But it's important that the client, the defendant, give the lawyer as much information as possible so that that lawyer can cover all of the bases and fully protect that client's rights.
So it doesn't sound like you're the get you off person. You are the person that makes sure that everything goes as it's supposed to go. And if in fact the evidence is not there, then the result that should happen would happen.
Right, because people often complain about defendants getting off on quote unquote a technicality. But the technicality is a law. It's based on the law, and we're all bound by the law. The job of the criminal defense lawyer is to make sure that defendant has an even playing field, a level playing field. The state has vast resources. They're funded by the state. They have scores of investigators, prosecutors, staff. A criminal defendant is alone with his lawyer. And so it's that criminal defense lawyer's job to level the playing field, to make sure that despite the vast resources of the state, that defendant gets a fair trial and that he plays on a level playing field and that all of the information that the state has, the defense has. And actually, the defense can sometimes be in a position where they actually have more information than the state, because if that defendant is honest with his lawyer and gives his lawyer all of the information the lawyer has the information from his client in addition to the information provided by the state, and then you can examine that all together and find out what the truth is and what is the best way to make sure that your client gets the best outcome.
Okay, so Rhonda, what would you say to those offenders that can't understand why you can't make the case end at arraignment? And what is that whole purpose of that arraignment process for the defendant?
Okay. First and foremost, the arraignment process, I always tell a client, the sole purpose of the arraignment process is to apprise you of the charges against you and to tell you that you have a right to have an attorney. Obviously, if we're already talking, he knows or she knows she has counsel, or she has a right to counsel. I always tell them that the arraignment process, if you go there, you can elect to go, and that the court is then required to read to you what the charges are and to tell you your rights. One of those rights, of course, being the right to counsel. A lot of times, though, we waive the arraignment, which does not mean, and I always have to convey to
So what do you mean
clients,
by that, waive the arraignment?
Absolutely. For people who have never been through the process, that can be a very scary concept, because obviously they want to make sure that they're not missing out on anything or you're not forfeiting any of their rights. So I try to make an effort to make sure that they're comfortable with the process of waiver of arraignment. And what that means specifically is this. We're putting the court on notice. When I say we, the attorney files a document with the court that pretty much states, I am the attorney of record. It's called an entry of appearance. At this time, we waive the formal arraignment. And what that means is, Judge, we don't need you to read to us on the record what the charges are, because I can read that to my client, and he's already represented by counsel. That's why I've already filed an entry. However, we would like to preserve our right to a jury trial. That's extremely important, because if you're in a lower jurisdictional court, such as like a state court, and in some cases a municipal court, you could be waiving your right to a jury trial, because some people, when they go in unrepresented, sign a form, a waiver of arraignment, and part of that language has in it that you're basically waiving your right to jury trial, and you're asking for the judge to rule on the case on its merits, which is considered a bench trial.
That's important. So we should understand what we're signing, and not just trying to get out of there early.
Absolutely. That's extremely important. So the whole point of the waiver, when you have an attorney, is I tell my clients this: you hired me to work for you. It's my privilege to do that, especially when people are employed or if I'm representing a child. Why take off time from work if you don't need to? I'll have a defendant. Why go through a process that's extremely nerve-wracking if you don't need to? The whole purpose of having an attorney is to help make the process a little bit more palatable. So that being said, I will sometimes file the waiver, preserve their right to a jury trial, and enter a plea of not guilty. Again, that's the other part of the arraignment that I neglected to state earlier. At the arraignment process, a party can either elect to state that they're guilty or not guilty. When we file our actual waivers, we file waiving the formal reading, entering a plea of not guilty, and we're preserving our right to a jury trial.
Okay.
For those limited defendants that still don't feel comfortable, I tell them, you know what, if you want to go through the arraignment process, it's my privilege to do that with you, my pleasure. We go to the court. I'll make them aware that you're going to be standing in line, generally speaking, for 30, 45 minutes, sometimes hours.
Longer than that.
Absolutely, depending on which
court you're going to.
Which court you're in, absolutely. In a higher volume court like Fulton and DeKalb, you can be there for literally half a day sometimes for just 2 minutes of walking up to the podium, signing a document, handing it back to the clerk of court, and then we ask, can we be excused? So if you're represented by counsel and you feel comfortable with your attorney, if they make a proposal of waiving an arraignment and you feel like they fully explain it to you, you have to trust their advice in that regard and just understand that you've not forfeited any rights.
And that's the most important thing, to make sure
Right.
that you tell them, don't forfeit any of my rights.
Absolutely.
Okay, well, we're going to take a break here, and we're going to come back and talk about that whole trial process, and how important is the jury important, or witnesses that see stuff? Is that important? How does that factor into all this? All right, we'll be back in a couple of seconds. You are tuned into Legally Speaking, a public service of You and the Law. You and the Law is a nonprofit whose mission is to provide legal information and legal resources to empower you in your legal affairs. If you would like to have a question answered or a topic featured on Legally Speaking, feel free to contact us online at www.youandthelawtoday.org. You can also sign up there on our website for our mailing list, as well as follow us on Facebook and Twitter. Remember, with every right comes responsibilities, so know your rights and accept your responsibility. Welcome back. We are in the midst of our Criminal Justice 101 series, and we're talking to Rhonda Kreuziger and Herbert Adams about the role of the defense attorney in this whole process. Before we left, we talked about the whole what the defense attorney does and how they do it. We talked about motions, we talked about arraignment and discovery and things of that nature. So now I want to kind of jump into, maybe we're at the arraignment and we said, okay, Ms. Adams, I did it. They got me on video, they got my written statement, the pictures. I mean, I did it. So at what point, if your client wants to take responsibility, and what is your role at that point in resolving the case for the client?
At that point, my role is to try to get a negotiation done with the prosecutor that results in my client having the most lenient sentence possible. So if, for instance, my client is charged with, let's say, robbery, and they have him on video, and robbery, of course, in Georgia is punishable from 1 to 20 years in prison. But it may be my client's first offense, and so that's quite a range, 1 to 20 years. And so I may early on talk to the prosecutor to try to get it resolved, either try to get the charge reduced to a theft by taking, for instance, or if we're stuck with robbery, to try to get him probation instead of any prison time. And depending on his age, his background, criminal history, other things, whether anyone was injured in the robbery, those factors, then he may be able to get a sentence of only probation and first offender, which means if he completes his probation without violating the law, he will not have a conviction on his record. So there are a lot of things that a lawyer can do, and again, it goes back to the client being forthcoming with his lawyer, giving the lawyer all the information he or she needs, and then that lawyer going through that information, that evidence, and then deciding on the best course of action for his or her client. And that oftentimes is a plea bargain that results, though, in a more lenient sentence than otherwise the defendant would be getting.
So what would you say to that individual I watched all the episodes of First 48. I've seen every Law and Order, Criminal Intent, SVU,
Right.
the whole 9. What I'm paying you for? All I got to do is do what I see happen on the show. What would you say to that particular client?
I would say to that client that don't believe everything you see on television. That's entertainment. In real life, it's very important that if you're charged with a crime, that you get a lawyer. It's also important that, as I said before, that you fully inform that lawyer about your case and trust that lawyer. As a practical matter, from a criminal defense standpoint, it's best that the client remain silent and not talk to the authorities before talking to the lawyer. That doesn't mean that you're guilty. It doesn't mean that you're innocent. It means that you're insisting on your right, your constitutional right to remain silent. And it's always best to do that. Well, 99.99% of the time, I won't say 100% of the time, but 99% of the time it's best to talk first with your lawyer, and that's against our instincts. Our instincts are just to tell
the truth,
immediately. And there's a time and a place for everything, as Solomon said. And initially, it's best to tell what you have to say to your lawyer, and then with your lawyer, then you go to the authorities, and your lawyer may advise you for whatever reason. There are many reasons and many considerations. The lawyer may advise you to remain silent and not go to the authorities. And in other cases, it's, he will say, okay, let's go and I'll go with you and meet with the detective and the district attorney, and then we'll get things worked out.
Okay, Rhonda, how important are witnesses to an incident that may have happened, whether it's a domestic violence type situation or it's a robbery or shoplifting or whatever? How important are they to the case that you're trying to present for a defendant?
They're extremely important. I don't know if you've ever heard the saying, there's two sides to every story, and then there's the truth.
And then the truth, yes.
What's interesting about a witness is it's always relative. It comes down to a person's perception. That's why it's important, if whenever possible, to speak to as many witnesses as possible. Don't just assume that because the police did an investigation and they actually interview witnesses and they've reduced those interviews to writing and you've gotten copies of them, that's all the information. Because the truth of the matter is sometimes when you're in a position when someone's asking you a question, you're not necessarily thinking about other facts. You're just, a lot of times, just trying to answer the question. So when I get my witness list, I still want to contact those witnesses myself. I need to know specifically what it is that they believe to be their side of the facts or their recitation of what occurred. Then you factor in just the human element of when you see something and you think about it, you've had a chance to think about it, you've had a chance to run it through your mind several times, you don't always realize that those events are not as you actually stated that they were. They're based on your perception of what occurred. That's why it's important to speak to more than one witness. But to me, one of the most essential parts of that is understanding the credibility of a witness. That when you have witnesses, whether it's law enforcement or whether it's a lay witness, credibility is huge. You don't want to set your client up for failure. Just because they tell you that so-and-so was with them, another person was present, and they had a chance to see it, and you go talk to them, and they give you all this information that strengthens your client's case, you still need to do further investigation. You need to understand, has that person ever been arrested before? Have they ever been charged with a crime of moral turpitude? And by that I mean,
so what's moral turpitude?
Have they ever entered a plea or have they ever been convicted of a crime that would bring their character into question? Have they ever been challenged with stealing something or fraud, or have they ever been shown to be dishonest? Because if you bring that witness forth and if you have them on the stand and you've not done your homework, checking into their credibility or the possibility of having some problems with their credibility, you might very well set your client up for failure. And also, they can help you in the case of a law enforcement officer. Oftentimes, people just automatically assume that the law enforcement officer is credible because he's a sworn officer. But the truth of the matter is they're human beings that go to work every day. They take their issues to work, they have their problems, and they also sometimes are not always of upright character. That certainly is not to disparage police officers. I respect them, they do a very important job, but they're still people. So unless you actually try to find out more about that officer, and by that I mean call your contacts, talk to other defense attorneys that have had their officer on the stand, talk to people that you know in the DA's office if you've had contacts, talk to other people who've actually had that law enforcement officer as a witness. How did he come across to the jurors? Do the judges automatically accept their statements as true? So again, credibility of a witness I find to be as equally important as what they have to say. Not only what they have to say is important, but who's saying it is my point.
So is that something that goes into in your whole thinking process, presentation on how it's going? That's what I'm hearing you say, that
Absolutely.
How it would come off, and that's part of your conversation that you're having with your client.
Absolutely. I want my client to understand that, again, my job is to help you, whatever that means. That does not mean help you hide the truth. I always tell clients, whether you pay somebody $10 or $10,000, we cannot reinvent the facts. They are what they are. The event has already occurred. All I can do is sift through the facts and the information to try to help you reach the right and the best result. And so when we talk to witnesses and we talk about witnesses, I have to tell them, guys, just because you have a certain person that you want me to talk to and you think this person is going to bolster your case, they might actually harm your case. Give me an opportunity to fully investigate and work for you. So you're right, presentation is key, but presentation goes to credibility, and you only can determine that through investigation.
Okay. Now, Herbert, tell us, how important is the jury, the private citizen, in this process?
I think it's paramount. I think the thing that distinguishes the United States from most countries in the world is the jury system. It's so important. The very notion that you can bring 12 strangers into a courtroom, have them swear an oath to listen to the evidence and not to make a decision until they've heard all of the evidence, and then to go into a room and meet in secret, no witnesses in that jury room, just them by themselves, and they reach a decision. I think that's so important to our system, and it's the thing that makes America unique. The criminal justice system could not exist properly without the jury.
So, Rhonda, what would you say to a private citizen that's watching right now about when they get their summons and they're trying to do everything in their power to get, I'm having a hernia surgery, my thyroid, whatever, to get out of jury service? What would you say to that person as to their responsibility in the whole criminal justice process?
I would tell them that in this moment you have a unique opportunity to be a part of the process. It's easy for people to stand on the outside and be a spectator and draw whatever conclusions they have about the criminal justice system and why it does not work. Now they have an opportunity to see firsthand, out of that, to see how the process works. And they also will have a chance to see that it's not as easy as people would think. As we mentioned earlier, people get a lot of their information from TV. Unfortunately, you don't have a script in the courtroom. We don't get hair and makeup. You have to go in there. It's real life people with real life situations. And I think that if they get an opportunity to serve as a juror, they will get an opportunity to see that the system actually does work when the parties go in there prepared and the evidence is properly presented. They'll get a chance to be a part of that. And I think they'll walk away from the whole process having a new appreciation for our criminal justice system.
All right. Excellent information. Thank you guys so much. Is there any area that we didn't cover that you think is important to all the folks out there in TV land, as they like to say?
I think you covered everything. And again, though, if a person's arrested and you're asked to waive your Miranda rights, 99% of the time do not do that. Always insist on having a lawyer before you talk to law enforcement. That's just for your own protection. That's my best advice.
And I would just add to that that when people ask me, do they need an attorney, I always tell them in most situations, 99% of them, and if it's a felony, 100%, the state is always represented by counsel, which means that you have a person in that courtroom who is prepared and armed with information and they know the rules of procedure. More importantly, the judge is an attorney, and they have a certain expectation too of the process properly working and the people being well versed with the evidentiary rules and the rules of procedure. So I would caution them before they walk into the courtroom. Certainly it's your constitutional right to represent yourself, but I think you're at a gross disadvantage when you go into that courtroom when you have other parties, mainly the prosecutor who is an attorney, and also the judge who is also an attorney. They know the system, they know the rules, they know the procedure. You don't necessarily know those, and unfortunately a law and order marathon won't prepare you. So
yeah,
you need
that's the truth.
So
I
you
can't
need
tell
to
you
go
how
with
many
preparation.
times I've seen something on law and order, okay, that does not happen.
It doesn't
God
happen.
bless them.
It doesn't happen. So they need to be prepared and have proper counsel.
Okay, so I got an issue. How can I find you, Ms. Kreuziger?
Well, we have a website. It's www.kreuzigerlaw.com.
You know you got to spell it.
I know. Kreuziger is a mouthful. KREUZIGERLAW.com. And our phone number is 770-626-5450.
And I heard if you didn't do it, we need to call Herbert.
That's right.
How do we
That's right.
find you, Herbert?
www.youdidn'tdoit.com.
That's cute.
youdidn'tdoit.com. We're right there.
And even if you did do it, you can call us. We'll help you.
Absolutely.
Yeah. Especially if you did do it.
That's right.
You don't take care of that. Well, thank you so much for being on the show. I know that the public got a wealth of information from you,
Thank you,
and
Alice.
it was extremely helpful.
Thank you.
Thank you.
As you know, everyone, on this show, we are all about resources and providing you information so that you can be empowered in your legal affairs. You've heard a great wealth of information about the criminal justice system and how the defense attorney factors into that. Remember that Legally Speaking is shown every Sunday at 6 on www.youandthelawtoday.org. And until next time, remember, with every right comes responsibilities. So know your rights, accept your responsibilities. We'll see you next week.